Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about a case out of the Court of Appeal for Ontario. There's two reasons. The first is it's kind of funny, but as with all things in court, when they're funny, they're typically funny because they're happening to someone else. They're usually a lot less funny for the people involved, certainly I suspect in this case. But they also present an opportunity to talk about self-represented individuals in the court, and the difficulties they face, the difficulties they cause for the courts, and sort of what can be done about that. So let's dive in here. This is the case of Jex and Jiang. So we see here Kevin Jex acting in person, which means that's a self-represented individual. And the others are represented by counsel, a Mr. Wong. So reasons for decision. The moving party, Kevin Jex, seeks leave to bring a motion to extend the time to perfect his appeal. So he's asking for more time. He wants an extension. And the reason why is to perfect his appeal, which means that he's filed a notice of appeal, but there's missing elements to it, missing documents. And so he says, I need more time to get those documents in. Please give me more time. This is super common with self-represented individuals because often they may not realize that certain things are necessary. You know, they file the notice of appeal, and then they're like, wait a minute, I had to get a transcript in? How do I do that? And, you know, something that's fairly straightforward for an appellate lawyer, like ordering a transcript, is new and challenging for a self-represented individual. So the courts tend to have to be fairly patient with self-represented individuals asking for more time in a way that they wouldn't with lawyers. Because, you know, if I go in and say, I need more time to perfect my notice of appeal, and they say, why? And it's, well, I haven't ordered the transcript. They're going to say, come on. They're not going to put up with that from me. But so that's one sort of area of challenge here. Now, we also see Mr. Jex is required by the April 30th, 2020 order of the Justice to obtain leave of this court before bringing any further motion for an extension of time to perfect his appeal. What that tells us is that the court is running out of patience, and they've said if you want to ask for more extensions, you first need to come and ask for permission to ask for more extensions. This tells us basically he's close to the end of his leash, or was at least at April 30th, 2020. Mr. Jex appeals the June 13th, 2019 dismissal of his action against the respondents following a 10-day jury trial. When you hear 10-day jury trial, what you should hear is many dollars. That was an expensive trial. Mr. Jex acted on his own behalf, so it would have been far less expensive for Mr. Jex than for the other side, who I suspect was probably also represented by counsel at that point. In his statement of claim, he sought damages arising from an August 29, 2007 motor vehicle accident involving the respondents. You can see how fast civil trials go. June 13th, 2019, it's dismissed. The accident happens 2007, so a little more than a decade to get that through the courts. The respondents were found to have caused the accident. However, Mr. Jex's action was dismissed on the basis that he had failed to prove that the accident caused any damages. Mr. Jex commenced his appeal on June 26, 2019. He has failed to perfect it. He has sought and obtained multiple and lengthy extensions of time to perfect his appeal. Starting with his first motion in August 2019, the present motion is the 8th in the series of motions seeking extensions. I will tell you, as counsel, if I was there asking for an 8th extension, you'd never get to 8. Like, you just would not. The court would shut you down long before you got to 8. So this just doesn't happen except with self-represented litigants. Is it in the interest of justice to grant Mr. Jex leave to bring his motion for an extension of time to perfect his appeal? It is not. As I shall explain, Mr. Jex's 8th motion is without any merit and constitutes an abusive process. In determining whether to grant an extension, the overarching consideration is whether the justice of the case requires the extension. And here the justice of the case seems to not mean the justice as in the presiding justice, but the justice as in the concept of justice within that case. The well-established criteria that inform this consideration include A, a continuing intention to appeal. So Are you still trying to bring this appeal and get it heard before the courts, or are you just jerking everybody around? The length and reason for the delay, the prejudice to the respondents. So that's, are the other side going to be harmed by you getting an extension? They're almost always going to be harmed in at least some sense, in the, in the notion of they would certainly prefer that you didn't get the extension and that you just lost the case as a result. But is it going to cause larger harms is going to be usually the main issue. And the merits of the appeal. And they cite some case law here. While the right of appeal is an important one, and therefore that they don't want to brush it aside just because somebody's made a trivial or paperwork error, a request to extend the timeline for perfection is fundamentally a request for the court's indulgence. Consequently, the justice of the case may also require an examination of the appellant's conduct, including the appellant's willingness to comply with established processes and prior court orders. Now, keep in mind, when the court is weighing this, especially in the context of a self-represented individual, their willingness to comply is going to be sort of seen through that lens, because a lot of people are willing to comply with the court's processes if they knew what the court's processes were. Self-represented individuals typically don't necessarily know that well, whereas a lawyer is going to be assumed to be aware of these things, and therefore is going to be held to a tighter standard to establish their willingness to comply. While Mr. Jex commenced his appeal in a timely manner, he has not demonstrated a continuing intention to proceed. He has unreasonably refused to take the appropriate steps to perfect the appeal, and he is engaged in conduct that is clearly frivolous, vexatious, and an abusive process. So a frivolous proceeding is one that is without merit, and a vexatious proceeding is a sort of a step beyond that. Usually it involves something being without merit, but it also suggests that you're proceeding with it in a way that is abusive to both other parties and to the court system itself. So vexatious is a step beyond frivolous. As his main excuse for his long-standing failure to perfect the appeal, Mr. Jex claims that he cannot obtain the requisite transcripts of evidence listed in his and the respondent's certificates of evidence. The record does not support his claim. Mr. Jex has obtained numerous and repeated indulgences to obtain the transcripts, including relief from the requirement to pay for the transcripts requested by the respondents in their certificate. So he doesn't even have to pay. He's getting these for free, and he still hasn't done it. Mr. Jex also received the early assistance of duty counsel and subsequent guidance from the respondent's counsel and the court reporter, so a whole lot of help has been going to Mr. Jex. There's no question that Mr. Jex understands what is required to obtain the transcripts. This court set out clear directions in 7 prior endorsements. Again, how do you get to 8? He simply refuses to do it. Despite court orders to the contrary, Mr. Jex persists in his unreasonable attempts to obtain fragments or isolated sentences of transcripts without making the required payment. It looks like he's only getting sort of half the transcripts for free. He has repeatedly and inappropriately sought to obtain discounts and free transcripts from the court reporter, or he has asked that the respondents or the court provide the transcripts. It was twice suggested by the justice in his reasons dated September 8th and November 9th that Mr. Jex should provide the court with updates on the status of the transcripts if he sought any further extensions. Mr. Jex did not provide an update, but instead argues for the first time that he does not have the court reporter's address and does not know where to send payment for the transcripts. This statement is unsupported by the record. Translation: the court is calling BS on this. The respondents produced exchanges between Mr. Jex and the court reporter, showing that Mr. Jex has repeatedly harangued and harassed the court reporter. Do you think the court's going to have much patience for that? Nope. In one of her last emails to Mr. Jex, dated October 1st, 2020, the court reporter accurately summarized this unfortunate state of affairs. You've been harassing me and threatening me for at least a year now. Your original order form to me was for an appeal. I told you that you would need 3 hard certified copies for your appeal. You didn't want to order that from me. You went away several times, and then another threatening email pops up from you. If you want to proceed with your original order, I'm prepared to prepare your hard copies for appeal. I have provided that estimate of cost to you on several occasions. In my mind, you are trying to bully me into providing these transcripts to you for free. As I told you before, you are welcome to get someone else to transcribe the matter for you. Otherwise, go back to my original estimate of costs I provided to you and send me the deposit, and I will prepare your transcripts for appeal. You must also provide your appeal file number, as that has to be inserted on the transcripts. So, when we think about this, remember how it was a 10-day jury trial? And remember how Mr. Jex was representing himself and the other side was represented by counsel? When we're talking about the actual cost balance here, Mr. Jex is taking very little costs and the other side is taking a whole lot of cost. They're having to spend a ton of money. And keep in mind that the ultimate decision on that was that they hadn't actually caused Mr. Jex any damage. So, car accident, but no damage caused. Okay. Think about how this feels on the other side. When you've got somebody who's not willing to pay the somewhat nominal costs for getting these transcripts, but wants you to incur huge, tremendous legal costs in terms of the appeal, the original trial. Starting to sound less funny, right? So this is something the court has to take into account because self-represented individuals kind of can skew the balance in this way. Mr. Jex has not complied with the court reporter's very reasonable and necessary requests. He's the author of almost 2 years' inexcusable delay in the perfection of his appeal. 2 years is an incredibly long time because usually appeals, you have to get all of the materials in on a fairly quick timeline. I'm not sure what it is exactly for Ontario. I'm not in Ontario. I next turn to the question of prejudice. Although the respondents have not pointed to discrete prejudice, such as the death of a party or a material witness, there's no question that the excessive delay in this case causes them prejudice. So discrete prejudice is something in this case of like evidence being lost, some reason why you wouldn't be able to properly defend the case. So that's, they give a couple of examples of that. Mr. Jex was entitled to commence an appeal. However, the respondents are entitled to have the appeal heard and disposed of in a timely manner. Until that occurs, they are deprived of the benefit of a final judgment relating to a motor vehicle accident that occurred in 2007. If you are the respondents in this case, do you think you're really keen to see the end of this, and especially to see the last of Mr. Jex? I bet you are. I mean, I bet that the thing that they most want at this stage in their life is to not hear from this guy ever again. With respect to the merits of Mr. Jex's appeal, his materials filed to date present no arguable issues for adjudication. The vast majority of his approximately 61 stated grounds of appeal are frivolous or vexatious, dealing with issues such as whether the trial judge erred in failing to make a peanut butter and jelly sandwich for Mr. Jex during the trial. Peanut butter, like he thinks that the trial judge, had a requirement to make him a PB&J. That's one of his grounds for appeal. The trial judge, the trial decision should be overturned because I didn't get a sandwich. I mean, this is probably an example of like the most frivolous / vexatious arguments. But you should never have that in your list of grounds for appeal. Like there is no reason. And certainly as a lawyer, I would never put that in. As a lawyer, you have an ethical responsibility not to bring frivolous arguments before the court. Now, that doesn't mean you can't bring sort of a novel argument, so long as there's some basis to believe that it could be accepted by the court. But I can't think of a circumstance where, you would require the trial judge to make a peanut butter and jelly sandwich for a party. There might be situations where the interests of fairness require that some sort of food be provided, but, hard to see what's going on here. Others relate solely to questions of liability on which Mr. Jex prevailed at trial and with which he should take no issue on appeal. For example, the color of his car, the fact that his car was rear-ended by the respondent's vehicle, and the location of the accident. They're saying, don't appeal this stuff because you won on it at the trial level. You don't want to overturn the issues you won on. Still others stand as mere conclusory statements without indicating any error, such as the statement that Mr. Jex has been suffering injuries caused by the accident in 2007. So, cool. How's that a screw up by the court? That's kind of what the Court of Appeal is saying here. Similarly, there is no support for Mr. Jex's allegation that the trial judge erred in continuing the trial when Mr. Jex appeared to lack capacity because the appellant had a differing personality that unfolded during trial of a 6-year-old capacity. Mr. Jex never raised this issue in this court, nor was there any suggestion in any of the court's endorsements that Mr. Jex lacked capacity to bring his motions or perfect his appeal. This one's starting to sound a little weird, isn't it? Many of Mr. Jex's claims for relief appear to be deliberately provocative. He seeks, for example, in his notice of appeal, to require respondents' counsel to submit to medical procedures and drug testing. The court doesn't do that. Like, you can't ask for the other side's lawyer to get a drug test. If the court has issues or if there's some issue with respect to the conduct, they may take other steps, but you can't just ask for that because you think it'd be funny. Mr. Jex has acknowledged that these requests are not serious, but serve as a metaphor for a blockage in communication. As such, they are frivolous, vexatious, and an abusive process. A notice of appeal is entirely the wrong place for, it's just a prank, bro. I'm not sure where the place for it's just a prank, bro is, but it's certainly not in your notice of appeal. I've also had the benefit of reviewing a complete record that was not entirely before my colleagues on the previous attendances, and which demonstrates that Mr. Jex has misled this court, which is a serious no-no, and deliberately and inexcusably delayed perfecting an appeal that has no chance of success. His improper use of the appeal process is plainly displayed in his letter received by Respondents' Counsel on November 10th, 2020, which was not before the court on the prior adjudications. Mr. Wong, I'll make you a deal. You have 24 hours to respond to the deal on the table. It shouldn't be too hard for you. For you to clear my name of any criminal conviction and get me back my gun license or pay me £150,000, and I'll walk away from this accident claim. There'll be no pardons. And if I was a lawyer with a degree, you would have paid me to walk away. I might have won. Maybe we can get back in front of Judge Chalmers again for a new trial. He's also one of my other favorite judges. Haven't seen him in a while. He still owes me a peanut butter and jelly sandwich with the homemade strawberry jam. If you choose not to, we'll just have a lot more many motions in court again since it's my new playground, and I'm having fun seeing you and Judge Zarnett, not to mention Judge Fairburn. She's like my dynamite in court in action. This could go on forever. He's one of my favorite judges, never ending. So the grammar in this is a little strange. This guy had a gun license? That's concerning. I'm not sure what's going on with that, but anyway, he's clearly making a demand here for some substantial cash and basically saying, if I don't get paid, I'm just going to keep jerking you around in court. So the court has no patience for this and continues on with, there is no basis to grant Mr. Jex leave or an 8th extension of time for the perfection of his appeal. To do so would bring the administration of justice into disrepute. His actions constitute an abusive process. At a certain point, enough is enough. That point has been reached here. Mr. Jex's motion is dismissed. The respondents do not seek costs. That seems incredibly generous, although I suspect that the reason why costs were not sought is that Mr. Jex probably doesn't have any money. He's probably an individual, and I'm just, this is my guess, but this seems like a situation where you would ask for costs, because this seems like a situation where you would get them. But if Mr. Jex has no money, that might be a reason not to pursue them, because you can't get blood from a stone. Mr. Jex has made reference to a criminal conviction. It may be that he's in custody. It may, we don't know. We don't know what his finances are here, but anyway, you can see what I mean about this is funny. He's asking the judge for a peanut butter and jelly sandwich. That's bizarre. But it's not so funny for the Jiangs in this case, because this would have cost them thousands of dollars, which we can see they're not getting back. So less funny for them. This illustrates some of the problems with self-represented individuals. Now, people have a right to self-represent, and that's something that shouldn't go away because there's reasons why people should have that, that power. But a lot of people who are self-representing are not doing so by choice. A lot of people are self-representing because they simply don't have the money. And that's unfortunate because I see fewer self-reps like Mr. Jex and a lot more self-reps who are just individuals who are trying their best and who really, want a fair hearing in court and would love to have a lawyer. They just don't have the dollars for it. This is a continual access to justice issue. It would be a better system if we had a way to provide for this to happen. This is a complicated issue, though, because law school is not cheap. I've still got law school debts. Lots of my colleagues do. Law school is expensive, and running a legal practice is expensive. Transcripts are expensive. I mean, comparatively, they're not that much of a cost, but they're still a lot of money. Everything involved costs money, and so it's a difficult problem to solve. And we see here some of how the court tries to help with that, which is recognizing that self-reps happen. And it looks like in this case, Mr. Jex was given above and beyond sort of opportunities to try to help him through the process. It's unfair to hold self-represented individuals to the same strict standards that we might hold counsel to. But in doing so, that can be unfair to the other side. The Jiangs would have much preferred if this ended at, say, 2 requests for an extension of time, as opposed to 8. So, how do you balance that? As I mentioned before, when you've got self-represented individuals, or even just a disparity in dollars, you can get abusive sort of stalling or cost-raising tactics. If you sue a major corporation, that corporation is going to be a lot less concerned about getting that matter heard efficiently than you are, because if the matter is expensive, that works to their advantage. Money, if you've got the larger pot, you can bully the other side a bit. So, but here, if you've got somebody who's got no skin in the game because they've got no money at all, they also can rack up costs. And this is we can see some indication here that he was unwilling to put even small amounts of money comparatively on the line here. And to be fair, if my grounds for appeal are that I didn't get a peanut butter and jelly sandwich, I probably wouldn't want to stake money on that either, So this is a very complicated issue. In a perfect world, everybody would have access to competent representation and nobody would run into financial issues. But we don't live in a perfect world in all sorts of ways. Ultimately, I'm sure that the Jiangs are happy to see the end of this one. I think that this is entirely a fair ruling. Eventually, the court has to say, listen, enough is enough. And assuming that the reasons for decision accurately reflect what's going on, I can't fault the decision at all. Anyway, I don't have answers here, I guess is the long and short of it. I just, I can see that we've got problems, but there isn't a clear solution to this. And I have tremendous sympathy for the Jiangs here. This looks like it was more than a decade in the making, and the court has trouble when people don't follow sort of its norms and expectations and can really go badly awry. Certainly that seems to have been the case with the appeal. I don't have any information as to what happened at the trial level. Maybe that was prosecuted differently, but it's kind of hard to imagine under these circumstances. So the courts are still trying to grapple with this. In some areas, we see, vexatious litigant provisions where the court can restrict your access to the court system. But the courts tend to be very reluctant to do that because restricting somebody's access to the court system can be a very heavy limitation. It can potentially bar people from getting remedies in situations where they may actually be justifiably injured and in need of a courtroom remedy. We haven't really figured out an ideal solution to this. There may not be one. The hard truth of a lot of life is that we have problems that cry out for some kind of solution, and often the solution is hard or just doesn't exist. We want a perfect solution, and perfect solutions are kind of rare in life. Anyway, thank you for watching. I hope that this has been somewhat enlightening. As I said, it's a bit of a funny case with the peanut butter and, jelly aspect, but there's more to it. And when I read this one, a lot of people were sort of sharing it around, commenting on the humor value, but it's important to see sort of the larger implications of what's going on here. Please let me know in the comments below what you think of this one. Please share it with your friends. Subscribe to see more content. I also want to thank my Patreon supporters who help keep this channel going. At the $50 level, Sir Daniel Wicks of Alberta, Jason Elliott, D. Moe, Canada's National Firearms Association, North Central Process Service, Kyle Martin, and Jean-Guy Toussaint. At the $20 level, Dale Nesbitt, Cameron Johnson, Andrew Elsich, and at the $30 level, Sights and Arms Limited, as well as a number of you at the $10 level who will be in the crawl immediately following. I've also been asked to give a shout out to a Tim. I hope I'm pronouncing that correctly. Anyway, thank you once again for watching, and I hope this is armed you with knowledge.